First, I want to thank you all for being here tonight and joining us for this event. This event is co-hosted by the Civil Appellate Law section of the Austin Bar Association and the Appellate section of the State Bar. And we also want to thank our sponsors for tonight, Vincent and Elkins, Alexander DuBose and Jefferson and Townsend, Thompson and Knight, and Norton Rose Fulbright. My name is Matthew Plager, and I'm the current chair of the Austin Bar Association Appellate Section. And I have the honor, as such, to perhaps turn the tables a little bit on the court today and ask them questions, though I promise I'm not going to cut you off or give you the red light. We're privileged to have 7 of the 9 justices with us tonight. We have, of course, Chief Justice Nathan Hecht, Justice Paul Green, Justice Phil Johnson, Justice Don Willett, Justice Eva Guzman, Justice Deborah Lehrman, and Justice Jeffrey Boyd. We know you're very busy, and we thank you very much for taking the time to meet with us tonight. Now, in case you were thinking that because we're missing 2 judges that we can gossip about them tonight, I want to disabuse you of that right now. We're being video recorded for posterity, and the court will post the video on its website in a few days, so you can review the highlights at your leisure. Now, I promise all the justices talk soon, but I just want to remind everyone that following the substantive portion of our discussion tonight, we'll be moving next door for a reception with an open bar and some tasty treats. So we hope you all will stay for that. Now, the state of the docket is one of the perennial questions that always fascinates appellate practitioners. So I just want to open this up for the Chief Justice to maybe just give us a little bit of an overview of what the current state of the docket is.
Well, first of all, thanks for having us this afternoon, and thanks to former Chief Justice Phillips and former Chief Justice Jefferson and Justice Brister for joining us. Everyone who has left seems to have big smiles on, so that's not lost on us. And glad to have Chief Justice Jones and former Justice Galtney here, who also reports that retirement is a good thing. Well, the good news is that we remain pretty well caught up and have carried over only a few cases that were argued before the end of the last fiscal year. We carried over 11, and the year before 7, and the year before 4. So 4, I think, was the best we have done since we've been keeping records, and 7 was close to it, and 11 was a little higher. But we're in pretty good shape. And hope to be this time. But Justice Lehrman, you want to
add to that a little bit?
Add to that?
Well, certainly, I'll be glad to. We certainly try to get our cases down to 0 if we can. That is something that we really work very hard to do. When we don't get it down to 0 by the end of the term, the reason typically, well, always, is because there's not consensus on the court. That means that we're not agreeing as to the correct application of the law, and we're trying to persuade each other as to how the law should be correctly applied. So I think it's important to remember that when the cases that are still pending, they're not pending there for lack of work. In fact, we're working really, really hard on those cases, but it just some cases just take a whole lot of study, a whole lot of writing, and sometimes many, many circulations. But if you look in the Bar Journal at the December of every year, our internal reporting dates are reported, and you'll see that we all keep up with our internal deadlines. We don't miss internal deadlines. But like I said, what's happening is we're just continuing to research the law and to try to get to the right answer. And I think we'll all agree that it's more important that we have the right answer than we have a quick answer. And those cases that we do hold over, I was looking a couple of weeks ago and for another presentation, and it turns out almost all of those cases go out very quickly within the next term. So it's not as if those are holding over for long periods of time. We really know that these cases are affecting people's lives, and we do our best to get them out as quickly as possible. And our goal is to get them down to 0.
Thank you. Now, it seems like a few years ago, the number of petitions being filed with the court dropped a bit, and it may be starting to go back up again now. I'm not sure. Do you have any thoughts on why the number of filings have dropped, and whether you're noticing any other trends in the filings of petitions?
In the past 5 years, the number of petitions went up a little bit and then came back down. But the variance is only about, the total variance was less than 10%. So it has remained steady, pretty much steady, during that period of time. And really, for the last 20 years or so, it has not changed a whole lot in a long time. The Courts of Appeals filings are about the same over a 5-year period. The Courts of Appeals dispose of about roughly 10,000 to 11,000 cases a year. So it's gone up again slightly and then come back down slightly, but it stayed pretty much the same. So it's hard for me to see a reason for why it goes up or down. Mandamuses went up a little bit for a while, now they've come back down. So it's kind of hard to see any trends there.
Justice Boyd, as one of the newer members of the court, can you give us sort of your impressions on the court, your work there? What surprised you? What hasn't surprised you?
I was asked that question once by a group of staff attorneys for courts of appeals, and I said, you know, the most surprising thing has just been the workload. We get like 1,000 petitions a year, and we decide 100 of them, and they just laugh me out of the room because the courts of appeals get many thousands. Now I say they're a mile wide and an inch deep, and we tend to be an inch wide and a mile deep on our cases, and they didn't like that either. So but I will say that truly the workload has been the most surprising thing to me. We have the petitions that we vote on every week by now Thursday noon deadlines. So if you get an order on Friday morning with a petition being denied, it means that either the day before or sometime prior to that, we all agreed to deny it. If we don't, we'll vote to discuss it and pull it off onto our agenda. But what that means is that I tell people it's like the equivalent of billable hours when I was in private practice. It's just like, and I don't mean keeping up with the 6-minute increments. I mean making sure you get your billable hours for the year. That pressure is what the petitions are for me. Every week you've got those petitions and you try and get ahead of them. You know, if you can have a great month with 300 hours or something, then you feel like, okay, I can rest for a little bit next month. The same thing here. If you get enough downtime to get 3 or 4 weeks ahead of the petitions, then the great relief is taken off of you. But otherwise, you're looking at 25 to 30 petitions a week. At first, it was, 45 minutes each. I mean, I was spending at least half my week just making sure I was reading all the Courts of Appeals opinions, all the petitions. I've learned now how valuable the summary of the argument section of your briefing is. Because once you read the Court of Appeals opinion, then you go read the summary of the argument, and usually at least half of them you can decide right at that point whether you think it's something we ought to discuss or not. So just the workload's really been the most surprising thing for me. It's constantly trying to keep up with it.
Right. Well, let's talk about some technology issues. When we last held this event 2 years ago, the court was just then implementing the TAMES case management system. I was wondering if you could tell us a little bit about how that has gone and whether that's led to any efficiencies in the way you work. I know You now get electronically filed briefs, you get an electronic voting system. Are you seeing any efficiencies in terms of how you quickly you can process cases and causes?
Justice Green?
I'd say yes. We are getting a lot of efficiencies there. One of the things that it's done for us is that as you everything's filed electronically in the court, and when we are working on petitions, of course, you can pop them up on the screen, and we have the dual panel screens there, and so you can have your one screen you can pull off the petition that you're looking at. On the left side, you've got the voting sheet, and it has a summary of things that you put in there. You can actually cut and paste items off of the petition that you like, things that you think are important that you want to talk about in conference. You can move those over and plug them into the summary area that you have for conference. And so all of these things, I think, are very useful to us individually as we work on these things, either remotely or at the office. And I think it has improved things quite a bit.
And with the implementation of this electronic filing, and I know the court has iPads, and they do quite a lot of reading. It's a much better situation for reading petitions. You no longer have to carry around the boxes of paper petitions. Now it's all available to you on your iPads. How much are you reading electronically? And are you also reading not just petitions, but briefs on the merits?
Yeah, I mean, everything is accessible that way, even on an iPhone. I mean, if you're somewhere, occasionally it'll happen that an issue comes up, an emergency motion and so forth, and so we'll get the actual document that's emailed to us along with the brief that's prepared by perhaps the mandamus attorney, and we can actually look at that on an iPhone, or wherever we might be. And so, yeah, all of those electronic devices, computers, laptops, iPads, iPhones are available to us, and that we do use those in the practice or in the.
Do you find certain techniques of crafting the briefs that are more congenial to reading on electronic format, or do you have any suggestions for how practitioners might make better use of that electronic reading the court's doing?
I personally, in the petitions, I like the electronic index that you can click on those and take you right to the part of the petition, or even in the brief itself. Those are very useful. Some people have learned how to do that, some people have not, but it's not a big deal, but it's just a convenience for me.
Justice Willett, how much electronic reading do you do?
A lot, but I confess, whenever it comes time to draft opinions, I print out stuff and I surround myself with it, and I like to sort of immerse myself and sort of marinate in paper. And this is really more on opinions that I'm drafting, whether authored majorities for the court or separate stuff. But I like to mark it, I like to tab it, I like to underline it and highlight it and fiddle with it. And I like to have it all around me. And it's, even though, well, I guess I'm no longer the youngest member on the court since Justice Brown arrived, but he's the first member of the court born in the 70s, if you can believe that. So I'm no longer the youngest on the court, but still pretty young. But I like printing paper. I apologize, but I do. And petitions and stuff I'll read online, but when I'm drafting, I like the tactile sensation.
Justice Johnson, what's your preference?
I've forgotten the question. What was the?
Electronic reading.
I don't use iPads very much because I get confused going back from Apple to Windows, and so at some point I'm sure they'll integrate those. But all of my reading I do on laptops, and I just carry it with me, so it's there, and I don't carry paper anymore. So I print out cases every now and then to highlight them and things of that nature. But I tried to at the point where we said we were going to have lawyers electronically file with the court, I took a deep breath and said, if they're going to have to do it, well, then I should also. And so I've tried to wean myself from paper at that point in time. And so I make an effort to do that, but I'm not an iPad, I'm just not an Apple person, but I'm a computer person.
I would like to point out that once going to electronic filing and the TAME system and so forth, some of us, me included, still take paper into the conference room to help in going through all this paperwork and so the cases. But the Chief Justice, I got to give him credit. He comes in with a laptop, no paper, and that's the way he conducts the conference. It's all electronic, so he's going all in.
Plus, I sit on the end, so nobody can see what I'm looking at on the laptop. Justice Guzman, what about you?
Well, I finally transitioned to electronic reading. It took me a while because I like your briefs, and you might see me on the bench with little different. I had a system with yellow or green or different color stickies depending on how I had coded something, and I like briefs, but I finally moved to electronic, and I got jealous because Justice Boyd also comes in with a laptop. So I went out and bought a Mac, and from now on, I'm coming in for a conference without the big binder with all of the study memos and the petitions. So I'm moving in that direction, but it's taken me a while. I have to confess, I like paper, like Justice Willett does. I like highlighting. That's how I process, and so sometimes I still print briefs, but I print them myself now instead of asking you to.
And we've gone through various iterations of the rule with what you need to file. And for a while, you recall, there was where you got to file a couple of paper copies in addition to the electronic stuff. And confession, I was one of those paper copies, and I think Justice Guzman was the other one. But we have since kind of waved the white flag and relinquished on that, and now it's all electronic and no paper required.
Justice Lehrman, you use a laptop at conference.
Oh, yeah. I use a laptop a lot, and I use my iPad quite a bit, and I enjoy that. But I also, I'm kind of like Justice Willett and Justice Guzman. When I'm really getting down and I'm really getting serious about an opinion that I'm working on, I really like to print those briefs out in hard paper, and I also kind of have my desk, and I surround myself with a paper because I like to just highlight. I like to take notes. Now, at the same time, I'm also oftentimes using my computer because I also like to cut and paste. And so and of course it's a lot easier to do it on a computer. So I'm cutting and pasting from using the electronic media to do that. But so I use a combination, but it's certainly, I know that without the electronic world, oh my goodness, I don't know what people used to do. I've written several legal texts, and I could have never done that. It's just unfathomable to me how people did that back in the day before we had the electronic wonder that we have today. So.
Increasingly, we're getting a lot of electronic records, and of course that will only continue to increase as electronic filing spreads. But that, I really think that is a wonderful change because now the record is really available to anybody in the court who just with the touch of a few buttons, and most of the time it's searchable and pretty good searchable, so that you can go through the clerk's record or the reporter's record, either one, and find things pretty easily. Where before it was a question of going down to the clerk's office and getting the record and then hauling it someplace and looking through it and taking it apart, and cutting all the ribbons and all the wax seals off of it, and all the injunctions about not separating it under penalty of law. And so that part has worked really well. And another big change, which now I think we just take for granted, is the use of email. Because the court was very slow to use email, and the principal reason was not that none of us knew how it worked, but the principal reason was that we were afraid that it would erode collegiality, and it would just be an excuse not to talk with each other face to face when we needed to. And as so many other people find out from time to time, would be taken wrong when you just abruptly say something in an email and hit send and then sort of wish you hadn't. But now we do we do almost all the emergency work through emails. So if anything that comes in requesting immediate attention is going to be circulated to the court by email. And I think, judging from the traffic I see, all of the judges respond pretty quickly, pretty much wherever they are. So it's a very quick way to get responses on things that need immediate attention. Before that, some of you who worked at the court will know that we rang the bell, which we have a bell in the ceiling of the floor, of the third floor, and there's a button in the conference room that sounds the bell. So if someone had an emergency requiring immediate attention, they'd go around to the conference room and punch the bell, and everybody was supposed to stop what they were doing and come down to the conference room and talk about whatever the emergency was, which we did, but we weren't always very happy when we had to do that. And so that we've changed that now. I don't remember the last time we rang the bell.
Someone was being taught how to ring the bell.
Right.
Nobody knows what it means anymore.
No. Or how to do it, because there's real art to ringing the bell. But now all of that's done by emails, and someone keeps up with the responses and sends them back around, either the mandamus attorney or whoever the designated attorney is on it. So it has really been a very good way to keep track of.
I heard in the pre-bell days, there was actually a triangle that somebody would roam around the halls kind of clanging like a dinner bell.
Right.
Is that right?
Yes, there was a cowbell, I think, at one point.
Did you hear that, or you seen firsthand?
No. I was there for the triangle. I don't remember the cowbell, but so we've technology's helped us quite a bit.
Well, let's talk now about maybe some rules. Over the years, the court has developed a really good close working relationship with the legislature on some issues, notably the rulemaking process, where the legislature will make policy and the court will then write rules to implement that policy. Can you give us kind of an update on what's going on with the Rules Committee, who the current liaison is, and Chief Justice, will you remain involved?
Yes, in the last several years, the court has had a very good collaborative arrangement with the legislature, in that they have been persuaded of the efficacy of setting policy, sometimes broadly, sometimes with more definition, and then instructing the rulemaking process to implement it. This really started about 12, 13 years ago, the first part of the last decade. Sometimes we get 2 or 3 requests or directions from the legislature to write rules. 2 sessions ago, we got 14, and some of them were pretty significant. Some of them are detailed, like preparing forms for expedited foreclosures. So this is a very, not very many lawyers do this, and so they know exactly what they need in these forms to present to judges. The judges can have input into what goes in there. And so in a relatively quick process, you can get forms that are immensely useful for those cases. Sometimes in 2003, the legislature just said, do whatever you think you need to for class actions. It was really just almost that broad. And what we did was import most of the changes that the federal rules had made about the same period of time. So it's varied from general directives to more specific things. But in all of this, I think there's been a lot of trust built up between the legislature and the court that this is a process that works and can be used to very good effect. Then that's kind of broadened. And last session, Chief Justice Jefferson helped bring together people that were interested in changes in the juvenile laws that criminalize schoolyard misconduct. And there was a lot of feeling that some of that conduct should not be criminal. And a lot of that feeling was among the judges who handle those cases. So this was something that directly impacted the judiciary, but was still really a policy matter for the legislature to decide. But in taking a role in that debate that was intended to be and ended up being constructive and helpful, I think, again, we just developed a strong relationship with the legislature, which I really think has been a very good thing. We don't have very much on our plate right this minute, but we will be restyling. That's the word the federal rule makers use, the Texas Rules of Evidence. So that's been done. And we had a very experienced and dedicated group of lawyers that really went through the rules of evidence word by word. And the product is much improved, a few substantive changes, and that's probably the biggest project that we need to turn to soon, but that'll be a big change.
Well, Chief Justice, you've remarked in the past that working with the legislature on these sorts of things is a bit like washing dishes, in that if you do a good job, you're probably going to get asked to do more. But if you break a few plates, you might not get asked so much. The court already has a full-time job of disposing of cases and liaising with a number of committees. I'm just wondering, it doesn't seem like you've really broken any plates yet. So is this a trend you see continuing, and how much of a burden is this on the court's time?
Well, it's some, because the Children's Commission takes a lot of time, and a lot of that work is aimed at the same kinds of legislative, judicial issues, interplay, and Justice Guzman is our liaison to the Children's Commission. So, but my own view of it, and from observing it in the last few years, is that most of the time judges go across the street for one thing, and that's more money for the courts and more money in salaries. So when the legislature sees you coming, they pretty much figure why you're there, and they start thinking of reasons to say no. If you go over there for other reasons, then they don't quite know why you're coming, and there's a better chance that you will be received better. And while I make light of it a little bit, I really do think that a cooperative spirit is helpful then when it comes to other things that the judiciary relies on the legislature for. So if we break any plates up, maybe there'll be small ones, Matt. But right now, we think it's a very good relationship.
Well, speaking of asking the legislature for money, the court has been recognized in the past, and quite deservedly so, for securing its efforts in securing funding for access to justice programs. And I just wondered if you could give us an update on the current state of funding and how those efforts are going these days.
there are really three sources of funding. There's federal funds for the Legal Services Corporation, and they reached an all-time high of about $420 million about 6 or 7 years ago. Since they got down to about 328, so that's a pretty steep cut. They're back up to 358 under the Paul Ryan continuing resolution. So the good news there is that very conservative budget writers in the Congress recognize the importance of access to justice, and we're heartened by that. The president has asked for $430 million in his budget. Probably we won't get that much, but we're expecting some kind of an increase. So we're sort of clawing our way back up there. IOLTA is still down to just a small fraction of what it was because interest rates are still at zero. And the state funding, the legislature has been very good to continue the funding at the same level it started in 2009. So generally things are a little bit better than they were for a while. But I do think that the attitude toward access to justice, certainly in the legislature, is very positive, but in the Congress is changing to the positive. I was there last week, and so was Chief Justice Jefferson and a number of other people. One very able congressman told me, he said, I have voted against access to justice in the past, and the reason was because, and these were his words, the reason was because I didn't know what I was doing. So I resisted the urge to say, well, I understand that goes on a lot up here. But it was very heartfelt, and he said, I'll never do it again. I'll be a supporter in the future. So little by little, I think the news there is encouraging.
Great. Now, I'm not sure if you're all aware of this or not, but this happens to be an election year. And it seems like every session we get, there are lots of proposals about how we choose and select our judges in Texas. You and former Chief Justice Jefferson recently testified for a House committee on, which included a number of proposals for changing the constitutional qualifications for appellate judges, maybe increasing the age requirement, merit selection, going to appointing judges with retention elections. Do these proposals have any more chance of surviving or going anywhere now than they have in the past?
Justice Willett, you want to take a shot at that?
By nature, I'm a cheery, upbeat guy by disposition and temperament.
You could tell by his dress, for example.
My attire tonight reflects the high esteem in which I hold the appellate bar. I'm only saddened that my colleagues don't. No, I'm a cheery guy by disposition and temperament, so I'm hopeful, but I am not remotely optimistic. And this is a perennial crusade by really good-hearted, servants who want to improve our state. You've all heard the quote from President Sam Houston, right? Able, honest, enlightened judiciary should be the first object of every people. Amen. I think we all agree with that. But we endeavor every 2 years, every session, there are people who, like Sisyphus, try to push this boulder up a very steep hill, and the wheels always come off. They may actually declare victory in one chamber, and it goes to the other chamber, and the wheels come off. And in my view, the battle's most kind of fiercely fought at the trial court level. There are a lot more of them, a lot more daily interaction with them, a lot more awareness and visibility, I guess. People are used to seeing more of their trial court judges, and I think the battle's most fiercely fought there. Both parties are on record, Democratic Party and Republican Party, favoring the status quo. They both have their pockets of kind of geographic strength, and a lot of it kind of boils down to whose political ox is getting gored. And but we have the system we have, for good or for ill. I've gotten very up close and personal with all the drawbacks, all the imperfections. They are plentiful. And I'm not going to detail them for you, but you know, judicial elections in our state have a distinctive sort of, you know, people go into the voting booth, and often for a lot of folks, it's eeny, meeny, miny, mo. I mean, especially in urban counties like Harris County, you've got multiple pages of, you know, trial court judges, and even for a lot of lawyers, they have no idea. And often it's, you know, what name is more alliterative or ear-pleasing or may ring a familiar bell or have a more judicial kind of flavor to it. You know, we inhabit an age of staggering, you know, civic ignorance. I mean, only 38% of Americans can name all 3 branches of government. It gets worse. Barely one-third can even name a single branch of government. And you had a U.S. senator not long ago on TV saying, hey, we've got 3 branches of government. We've got a House, and we've got a Senate, and we've got a president. And so we're sort of the Rodney Dangerfield of our system. But if you ask Texas voters, are you willing to surrender your right to elect your judges? Absolutely not. Over my dead body, no way. Well, can you name one? Name one. And, you know, blank stare often. But, you know, people cling tenaciously, jealously. They guard jealously their right to make what are often uninformed decisions. There are some proposals. There's the interim committee you mentioned. They're going to take I think a top to bottom look again, you know, and I'm sure like every blue ribbon panel in the last, you know, few generations, they'll recommend smart reforms, but I'm not optimistic. And there's some other kind of more piecemeal, incremental ideas. If you're not going to just completely overhaul the system and move to retention or merit selection or whatever, maybe there are some smaller kind of baby steps you can take. You know, Senator Patrick, who may well, and we'll see how the election goes, he may well be Lieutenant Governor Patrick. He's proposed in the past removing judges from the straight ticket. They'd still have their partisan label attached, but you'd have to affirmatively, intentionally go down the ballot to vote for your judges. And I don't know how people would feel about that. Again, it may come down to a political calculation of who believes they're more harmed or more helped. I read earlier this week on Twitter, of all things, there's an Ohio Supreme Court candidate who wants to move the high court elections in Ohio to the very top of the ballot, above governor and above everything else, in hopes it may kind of boost awareness and draw more attention to these very obscure down ballot races. And we'll see. So, I mean, bottom line, I am capital H hopeful, but not at all optimistic.
Let me add to that. 10 or 15 years ago, there was a survey done in the state, commissioned by the court and OCA, I think, and other state bar maybe, asking Texas voters whether they thought that contributions to judicial candidates or judges affected the decision-making by the judge. And like more than 80% said yes. Well, you know, 80% of the Texans think that that's happening, and they think it's a corrupt system. So why wouldn't you want to change it? But Justice Willett is correct. You know, it's very easy to, you know, feel that way. But when you talk about taking away somebody's right to vote for the judge of their choice, whether they know him or not, you know, Houston for Harris County have 75 judges on the ballot, 75 courts on the ballot to be decided. You know, if you work really, really hard trying to figure out who the right person to vote for in each of those races, I mean, you still couldn't do it. And yet, that is the system, and the chances of it being changed. When I first came on the Court of Appeals in 1995, there's discussions about changing it. I thought, all right, it's going to happen. Well, here it is, almost 20 years later, and of course, nothing's significant has really happened, and I think that's going to continue.
Well, on that upbeat note,
Well, I'm curious, how many of you think it should be changed? Now, how many of you think it should not be changed? See, I'm reminded of one of my favorite all-time stories about the Bible school teacher on a Sunday morning, had these little kids and was saying, all right, I'm gonna tell you a story, and it's about this little animal. It's bushy and brown. Anyone know what I'm talking about? And the little kids are all shy, and the next one, well, it's bushy and brown, has a big, long, bushy tail. You know what I'm talking? Nobody wants to raise their hand. And it climbs trees and it eats nuts. And finally, a little girl on the front row raises her hand and says, well, it sounds like a squirrel, but I'll say Jesus. You know, I have found that being with this group, when you talk about judicial selection, we're talking about Jesus, man. You gotta say, you know, there's no room to say no. But you got to Gillespie County, and they don't get it. Why would they want somebody in Austin telling them who their district court judge is gonna be? Or Bernie, or Milam County, or, you know, all the, so, and I'm gonna say squirrel here, enough to say that I've decided I'm holding my decision till after I've at least been through an election. Now, hopefully the outcome of the election won't change it one way or the other, but I want to at least have experienced it. Because I will say that if I were just appointed and didn't have to run for election, there are a whole bunch of voters all over the state that would have never gotten to meet their new Supreme Court justice. But because I have to run, I'm out there meeting voters and letting them know who's on this court and what this court does. And so I see good and bad. I do agree. Overall, from this perspective, right now, I think we need a change. But I'm holding my vote until I've at least been around long enough. And so the one or two of you that raised your hand, thanks for saying squirrel. I think we need to keep debating this. So.
One thing I'd like to add to that is that when I speak to people out on the campaign trail or wherever about this issue, and people ask a lot about what my views are, and then we get into this conversation about whether they think that judges should be elected or appointed. And when they say that they think that the judges should be elected, what I get back a lot is that they believe that the only alternative is the appointment system as we have it here. And so they don't like that. And what they don't like about that is that there's no transparency. You know, it happens in in the governor's office. Of course, we know that the governor makes
Totally
the
corrupt.
appointment.
The way that system works.
And so I think that if we could educate people more that there is an alternative with merit selection where you would have hopefully the best of both worlds, because you would hopefully have an impartial panel of people who knew what it takes to have a good judiciary, and that they would be appointed in a way that would be fair and impartial, and they would then submit so many names to the governor, and then the governor would make an appointment, and then you would be up for retention, and you would go around the state, like Justice Boyd is talking about, to meet people and get to know people because you're up for the retention election. So you have a certain element of transparency. You have much more, I believe we are independent, but certainly perceived independence. And then you have accountability as well. And I don't mean accountability to the people who vote for you, but I mean accountability in terms of being a good jurist, a good, fair jurist doing what you need to do. So I think a lot of it's education and people not knowing that those are not the only two alternatives out there. We know that in this room, but a lot of people out there don't know that.
And just a quick PS, I mean, I've not cracked the code. I've run, I guess now twice statewide, always with opposition. You spend every waking moment in campaign mode. I mean, job one is keeping your job. And there are many aspects of it that are just unseemly and crass and undignified that don't inspire a lot of public confidence. But again, when that cycle comes around, you got to put on your game face and tackle it with gusto. But I've not cracked the code on what the perfect replacement ought to be. I think every reform proposal has drawbacks and kinks, and you move to a commission or a panel that tees up a list, and somebody picks off the list. Well, how is the commission chosen, and who picks the pickers, and is there a risk of capture of that body? What sort of biases may be hardwired into that group of folks? And there are all kinds of objections to every reform proposal, which isn't to say we shouldn't do anything at all. And I agree with Justice Boyd. The biggest virtue, I think, of our system is it really forces judges like us. We live a pretty cloistered life, a pretty rarefied environment, and I think it's really beneficial to nudge us to sort of descend from this bubble we inhabit sometimes and really have occasion to intersect with a really fascinating cross-section of people from every corner of our state. That's what I really enjoy the most. I mean, judges by nature and disposition are often, especially appellate judges, often not especially extroverted by nature, more sort of withdrawn, and nobody on this panel, but socially a little lacking. But judges are just sort of studious and bookish and a little nerdy at times, which is endearing, right? Yeah, bow ties, right? But I enjoy traveling to 254 counties every so often and meeting just a fascinating group of folks who I'd really otherwise have no occasion to really intersect much with, and I really enjoy the heck out of that.
I don't want to add anything to that, except I will say this in regard to the debate. First of all, I don't think we're going to change. That's my view, and we don't need to go into that. But the last time I ran in 2008, Chief Justice Jefferson was on the ballot and had an opponent, Democratic opponent. And Justice Wainwright was on the ballot with a Democratic opponent, and I was on the ballot with a Democratic opponent. We were having a televised debate, closed circuit televised debate in Houston. And that very same question was asked. And I'm in place 8, so we were by places, Chief, and then Justice Wainwright, and then it got to me. And the answer to that question, starting with Chief Justice Jefferson, and I think his views are well known, we ought to do it a different way. And his opponent said, we ought to do it a different way. And then it got to Justice Wainwright, we ought to do it a different way. And it got his opponent, we ought to do it a different way. And my opponent went first and said, we ought to do it a different way. And my position was it didn't matter because, the people weren't going to do it. But the significance of that is no one really started hammering them for that. And I think the newspapers realize, and I've seen some articles in newspapers and opinions saying, just what you've heard up here. How can we, and the newspapers really, the metropolitan areas, they will try to do their research and they try to endorse. But they have said, I've had them say to me, how can we know who's the best qualified when we have 30 or 40 candidates for district court, then we have county court at law judges, then we have the appellate judges, then we have, how can we know? We can't make a recommendation. And if we are paid to find out, how can we know? So that reflects, but the significance of that debate is now that when you say we ought to do it some other way, you don't just get scalded in the press. Where it used to be that your opponent would say, that person is for taking away your right to vote. We don't hear that now because there truly is maybe a little bit of a shift in the debate, although I don't think it's going to happen too soon that we change.
So I'll just weigh in. The studies that have been conducted on dispositive outcomes in jurisdictions where judges are elected and where they're selected through some other method don't reveal any significant differences in dispositive outcomes on critical issues or the types of issues that you would associate with political ideology. That being said, though, the issue is critical because I believe the public's perception, their confidence in our system of justice, is impacted by the way judges choose to campaign. And some of the campaigns, as you well know, are appalling. Judges who are supposed to be held to a higher standard choose to campaign in a manner that really denigrates our system of justice. And so we, as a judiciary, have an obligation to run our races and to engage with the public in a manner that furthers their confidence in the system. But sometimes we choose to do otherwise. And so I think it's important, as long as we do have the system that we have, that we as judges shoulder some of the responsibility for how the public receives information about judicial races.
Thank you. Let's turn now to petition practice before the court. As we all know, we've now switched from page limits to word limits. And I just wanted to know if the court has noticed any changes or trends to do with that switch, other than perhaps the now more aggressive use of hyphenation.
Justice Green?
Well, what I've really noticed is that it seems to give the attorneys more freedom to, put things in like graphs and pictures. And that's very helpful because, as has been mentioned, we have a lot of reading to do. And so anytime that you can put something in there that's going to make it easier for us to understand the point that you're trying to make, the better. And so what I've noticed is that people, I think, are much more apt to do that. I remember a brief that Justice Brister did, and he had done something like that not too long ago, and it was very helpful. And I've seen quite a bit of that. And what I really like is that you all are using a larger font now. It's great because it's a lot easier to read, of course. So I've seen it to be a very positive thing because it's really helped me to read it. And I think it's given you all, at least from my perspective, more flexibility to add things that you may not otherwise add, that it's going to make it easier for us to understand your points.
There was some controversy that some of you may be aware of when we went to the word limit rather than page limit, and that in effect it deleted a page, worked out to deleting a page, and the people weren't happy about that. Although I don't think that any petition has been granted or denied because of what was put on the last page of the petition. So I don't really think it's affected how we look at the cases, how we look at the petitions. As Justice Lerman points out, it's helped us. I think those of us with old eyes, the font sizes help. You don't have to worry about that anymore, and things of that nature. And so I don't think it's harmed any of the advocates who are filing things in the court.
There's a lot of things I've learned since joining the court that I wish I knew when I was a practitioner. And one of them, I'm telling you, practically speaking, we read so much going through these petitions, trying to catch our attention to vote, hey, this is one we ought to discuss, that I think now that if I ever leave the court and go back to practice, I think I could write a great petition that's 3 pages long. Because when you've got to read all of them and you've spent 45 minutes times 25 on Tuesday, Wednesday of every week, it just blurs. But the shorter, I promise, and I know I got in trouble over this last time I said it because I learned under Brian Garner how to do deep issues. Don't do deep issues. Just say the issue in this case is did the trial court err in severing the negligence claim or whatever. That's all I need to know. And then I promise I'm going to read the summary of your argument at least, if not your whole argument, depending on what the Court of Appeals did. Truly, the shorter the better.
I think that the issue is sort of the lens through which the judge is going to read your petition. So an issue that's very engaging, that highlights why this is important to the jurisprudence of the state, in my view. So we talked about this the last time we were on a panel, but in my view, an issue that that will capture the judge's interest immediately. I tend to, as Justice Brister did when he was on the court, go straight to the Court of Appeals opinion, most of the time, I know the justices, and I know how they work, and I know what's in there, and I know what, you know, how they write, and so I go there and then I come back, but your issue, in my view, is what immediately engages me. It's the hook, as Doug has coined that phrase. It's the hook for the judge.
Well, I'll note that appellate practitioners rarely run out of things that they feel like the court just absolutely needs to know to decide a case, and often are at pains to restrain themselves in offering their help to the court. But sometimes, because of this or because of the wishes of a client, they may be tempted to file additional briefs. They're not necessarily contemplated by the rules. SIR replies, supplemental briefs, post-submission briefs, those sorts of things does that just add more pages or bits, as the case may be, for the court to consider? Do you find them helpful? And if so, what types?
Justice Johnson?
Well, we can always use more help, but, you know, if we haven't grasped what the issue is with your brief and your response, with the original and then the response and then the reply to the response, we probably are not going to grasp it. Now, if in oral argument questions come up that really need to be fleshed out, then I think we welcome those. But sometimes you get into, well, if they file a brief, then I've got to file a brief, and then what they said is not right, and, you know, but I'm not sure that unless something comes up in oral argument, why we just need to have briefs going on and on.
Let's talk now about amicus briefs, otherwise known as amicus briefs. According to statistics prepared by Don Cruz, the court on average receives about 180 amicus briefs per term, but in the 2013 term, according to admittedly unscientific research conducted by my good friend Lisa Hobbs, there are only 9 references to amicus briefs in the court's opinions, and only one of those was cited positively by the majority opinion. So this calls a little bit into question how useful these are to the court. So indeed, how helpful are they, and what would make them more helpful?
Justice Green?
Well, okay. Of course, you know what amicus curiae is Latin for curious amigo. But yeah, you know, they're useful. I mean, it highlights an issue that perhaps sometimes needs to be highlighted to us. Sometimes it doesn't necessarily have to be, doesn't need that. But I think it gives us a perspective on an issue that maybe the briefing, which of course is typically concentrated on that particular case, gives us a broader view of the issue and how it affects jurisprudence in that particular industry, for example. Whether insurance, oil and gas, whatever, we get these things and how it affects them. Interestingly, you know, we'll get an amicus sometimes. There was an oil and gas case some time ago that says, look, the petitioner's asking you to interpret this joint operating agreement provision a certain way, and if you do that, that's not the way we do it out in the field. Well, you know, we didn't ask for the case, but when presented with the language, we have to interpret the language as it's written, not as what people are telling us the way that they do it out on the rig somewhere or on some lease. But it is interesting to know and helpful to us to find out, you know, how the real world views some of these issues when they come up.
I mean, I agree. I really enjoy amicus briefs, and the sooner the better, frankly. Don Cruz and I did a tag team CLE a few weeks ago where amicus briefs were kind of a subtopic of our overall presentation. He had some really nifty kind of charts and graphs, which maybe on his website. Don, are they? I don't know. Not yet, but I'm sure they will be soon. I love amicus briefs, and again, I think, you know, the sooner you can put them before us, and, you know, not wait until a motion for rehearing and then kind of wag a disapproving finger at the court for how we've sort of wrecked the plan of salvation or how the world is going to spin into outer orbit or something. It'd be better if we kind of knew all that earlier, even kind of, not at rehearing, but at the merits briefing stage or even at the petition stage. I mean, often, litigants are so fervently focused on their case, the facts, the record, restricted to their case. And there's often a larger context and a bigger picture with more industry-wide or society-wide ripple effects. And it's helpful for the court to know that. I don't care about amicus briefs that just sort of give a Me Too regurgitation of what the parties have said, but if there's a different angle, something distinctive, unique, that gives a broader context. In the infamous dog case that I drew a couple years ago, we got a lot of amicus briefs trying to alert the court to kind of a bigger picture out there. That this wasn't just a case about poor 8-year-old beloved Avery the pet. This was a much bigger deal. So I enjoy them a great deal, and earlier in the pipeline, the better, as far as I'm concerned.
I'd also like to note that the State Bar Appellate Section, our co-host tonight, has recently set up a committee, an amicus committee, for the section that has set guidelines for when the section itself may want to file an amicus brief to provide particular help to the court that their membership may have certain expertise in. Do you anticipate the court asking the section to weigh in on certain things?
Oh, I doubt it. I think we would depend on the section to make that decision. But certainly welcome the input. We've had a very good practice of inviting the Solicitor General to comment on cases, and I think the Solicitor General has responded every time we've asked. So a lot of times we get cases that may impact statutes or have statewide ramifications besides just the impact on parties or parties similarly situated. So it's good to have the Solicitor General's views.
Going with that, the courts are now required by statute to notify the Attorney General if there's a case that involves the challenge to the constitutionality of a state statute. I know the 14th Court of Appeals has at times requested the views of the Attorney General and hasn't really gotten a whole lot of response. And recently, the Court of Criminal Appeals has held that this statute violates the separation of powers doctrine. Now, I have not notified the Attorney General that I was going to ask this question. I certainly don't expect the court to pass on the constitutionality of that statute at this point, but I would like to know sort of what the court's policy is on when it would call for the views of the Solicitor General.
Well, we don't really have a policy. We vote on it, just like everything else. But again, if there were an issue that that was going to impact, for example, in a private case, and it impacted something the Attorney General does all the time, like child support, or if there were certainly a constitutional issue or an issue that was going to affect not just the state like all our cases do, but have a more direct impact to the state, we would ask for the Solicitor General's views, because neither party may be presenting what the Solicitor General thinks should be the law. The request, there's a very old federal statute. It's about close to 70 years old, or maybe older than that, that requires federal courts to notify the U.S. Attorney General when constitutional issues are raised in cases. And The federal rules of civil procedure, well, all the rules were changed some years ago to give a procedure for effectuating that. I think it was in the course of that the Attorney General asked for and got legislation requiring the similar notice to him from the state courts. In the federal system, the federal courts are required to notify both the U.S. Attorney General and any state Attorney General that they think is affected by the issue as well. So the federal system gives notice to both federal and state legal officers, whereas the state just requires notice to the state Attorney General, and that's the statute that the Court of Criminal Appeals held was unconstitutional.
One thing I'd like to add too, that whenever you are deciding whether or not to do an amicus brief, I think Justice Willett alluded to this, but make sure it's not just Me Too briefing. And I can recall several times when we have asked for some opinions, and it's been a little bit more Me Too than I think what we were looking for. And so remember, that's a really when we're asking for that, we're asking for something a little bit broader than what's already in the brief. So pay a lot of attention to that. And I think all of us really appreciate good amicus briefs that are bringing us some information that we don't already have, that may be something on policy issues, maybe something about, jurisprudence in other jurisdictions, those kinds of things. But having said that, and how much we appreciate that, when someone's preparing their case, and we have a lot of amicus briefs that do tend to be coming in and just Me Too type briefs, that we can realize that also that can be just a strategic plan that may not necessarily work. So remember that they're helpful when they really are giving more information, but as a strategy, it's not going to work.
The Austin Bar Association is in the process now of developing a rapid response team that would respond to press attacks on the court or to mischaracterizations of the court's decisions and other things about the court and the press. I believe the Dallas Bar already has one of these. I'm not sure if they have SWAT-style uniforms or maybe a badge of some sort. I certainly hope so. And I'm sure that there are times the court would like to respond to mischaracterizations of their work in the press, but is not really institutionally well-suited to do so, speaking mostly through its opinions. Other branches, the governor's office, and certainly the attorney general's office, have these sorts of PR teams that can respond immediately. I wondered, do you see a need for these sort of response teams, and how do you feel about the bar speaking on your behalf?
Well, yes, there's a crying need for it. They didn't respond. I think we would all welcome that in a sense. I think it's hard. I mean, I think professional reminders to the media that the courts are supposed to be independent, those kinds of things would be helpful. I think, when there are attacks, if there were a way to do it, I think we'd all be in favor of having more champions. But it's kind of hard to see how it would work.
We do have Osler,
Yeah, right.
who covers part of that for us, and the thought there's certain attacks that you shouldn't respond to, and there are others that you just can't respond to as a court. But I'm remembering, and I don't know if Osler will, but a few months ago, 6 months ago, I don't know, within the last 6 months anyway, there was a particular opinion that went out, and I saw a news article that came out that was addressing it, and it was kind of critical, and there was just one key point that was just wrong in the news article. And so I immediately started typing an email to Osler to say, can you call this reporter and tell him that it's, and before I could get it done, we got an email from Osler saying, by the way, you may have seen this article. I've talked to the reporter. He's going to correct it on the online version. And so there is some level of that we can do through Osler and our, I was about to say in his office, and Osler.
You know, I'm not sure what that you can really do about it. People have their perceptions, they see an outcome, and they don't like the outcome, and sometimes it's worthy of media attention, and they write their stories and so forth, but a reaction might be, well, you could write something to correct it, but we've already written something. And so you could just refer back to the opinion out. We try very hard to explain the decisions that we make and to people who may not agree with the outcome, but at least they can read and find out why we came to that conclusion. So if a written response is the answer, I mean, it's really unnecessary because we've already written something.
And I think that as members of the judiciary and the bar, we have a common interest whenever the institutional legitimacy of the court is attacked. And so to the extent that the responses or the contributions from the bar were aimed at protecting and helping to preserve that legitimacy, I think that would be wonderful.
I agree with that. Just last month, the president of the Tarrant County Bar Association wrote in the brochure that comes out every month, her opening letter on the front page was about this exact topic. And a judge in Tarrant County had made a decision that wasn't very popular and had gotten a lot of attacks by a lot of different groups and by the media. And she really made the point about how important it is for those of us in the legal profession to be sure and stand up for that. And whether we agree with it or we don't agree with it, to make the point that this is an independent branch of government and the importance of that. And so I really think that the bar can do a lot in really stressing the importance of that, and certainly more than we can, and we can't in any individual case. We can do it certainly generally. But I think that it can be done, and I know that I think I can speak for all of us that we certainly appreciate that, but not just for ourselves. It's important for our society at large because, of course, the third branch of government has got to be respected for the rule of law to have any meaning. And so I think it's a great movement, and I really appreciate the effort.
And speaking of the state bar, what is the court's current relationship with the state bar?
We have liaison positions at the court, as mentioned. For example, Justice Guzman is the court's liaison to the Children, Youth, and Family, and I work with the state bar. And I think the relationship with the bar is good, as it is with the legislature. Now, we don't always, as a court, agree with what the bar does, and the bar certainly does not always agree with what we do. But the bar and the court are communicating, and I think we have an open level of communication between the court and the bar.
All right, well, I think that that's pretty much what we have tonight for our substantive portion of our evening. Please join me in thanking the court for talking with us tonight.